Well, good afternoon, everyone. My name's Aaron Woodrick. I'm the Director of the Domestic Policy Program at the Macdonald-Laurier Institute. I want to welcome you all to today's webinar. We're going to be discussing the recent Alberta Court of Appeal decision. It was a reference case regarding the Impact Assessment Act. The Alberta Court of Appeal, of course, found that federal law was unconstitutional on the grounds that it subjected intra-provincial resource development projects to a federal public interest assessment and therefore gave the federal government veto power. This is probably more familiar to a lot of people as a bill known as Bill C-69. It was also colloquially called the No More in Pipelines Bill. And this decision, of course, has made quite a splash. So we've assembled, I think, a pretty eminent panel to discuss this decision, unpack it, and talk about what it means. So I'm very pleased today to be joined by Dwight Newman, who's the Canada Research Chair in Indigenous Rights and Constitutional and International Law at the University of Saskatchewan and a Monk Senior Fellow at the Macdonald-Laurier Institute. Shannon Joseph, who's Vice President, Government Relations and Indigenous Affairs at the Canadian Association of Petroleum Producers. Ken Coates, the Canada Research Chair in Regional Innovation at the University of Saskatchewan and a Distinguished Fellow at the Macdonald-Laurier Institute. And last but certainly not least, Heather Exner-Perot, who is also a Senior Fellow with us here at MLI. Welcome to all of you, and thank you for joining us. I thought that we might start today by just sort of getting your impressions, if you can, just sort of brief impressions on the decision, what it means to your sort of industry or the area of your academic specialization, and sort of how you think, I guess in your case, Dwight, what the court's reasoning was. I'll start with you, Dwight.
Sure. So I mean, it's a big division of powers decision from my standpoint, and I don't know if people were expecting this necessarily, but it's come out strongly in favor of the province, and obviously involves a striking down of the federal legislation, the Impact Assessment Act part of Bill C-69. There are two key pieces to the reasoning there, and I think one of them involves some significant legal synthesis by the Alberta Court of Appeal that there's going to be argument over, no doubt, and that pertains to the provincial jurisdiction in relation to natural resources and the scope of that. And they say some things about that from a legal standpoint. And that's one key piece to the reasoning. And the other key piece is the characterization of the Impact Assessment Act as involving essentially an attempt to federally regulate every resource project, including those that are within the scope of intra-provincial projects that they say are in provincial jurisdiction. And that second piece will also be argued over, but those are significant conclusions about a piece of legislation the federal government thought they had the authority to implement, and now has been struck down at this stage, subject to what the Supreme Court of Canada says.
Yeah, and we'll be sure, Dwight, to circle back on some of the legal reasoning. But Shannon, I want to go to you as well, just to get the sort of industry perspective. What this ruling means for the sector.
Well, I think that industry is very supportive of having responsible resource development. I think we were very engaged when Bill C-69 was going through the legislature, because we saw opportunities for improvement and potential areas where, if there were not changes, could cause a lot of uncertainty. And one of the areas that has been very important to us and to our members is to avoid duplication in project review. And we thought we remain in our submission. We thought it was very important for provincially things that were intra-provincial to, as much as possible, be reviewed through provincial regulatory processes, and that should be a principle of how some of these things are approached. So we saw in the court decision a lot of validation of some of the ideas we put forward in our brief, the importance of respecting provincial jurisdiction, questions around the use of GHG as a basis for reviewing intra-provincial projects. We didn't think its use was appropriate, and we had conveyed that in our brief. And so I think, as Dwight said, the conversation goes on, and this is going to be appealed. And so, I think we look forward to seeing how that lands, and again, to having a framework that provides business what they need to have the certainty they need to invest and move forward.
Yeah, that's a fair point coming from business, because it's not just a constitutional law issue; it's also just a ability to do business, a red tape issue, in other words. So, very interesting. Ken, I wanted to go to you on sort of as a proud Westerner or Northerner, even. What your view is of the impact of this decision on the parts of the country where the types of economic activity that would be regulated by this act feel. What's the sort of impact there?
Well, I always wonder if the good folks in Ottawa heard the loud cheers that came out of Alberta, Saskatchewan, other parts of Western Canada when this decision was announced. Federal government, provincial government, been fighting over natural resource development since the 1930s. It's an ongoing sort of theme. In the Harper government sort of approach was really to get out of the way of resource development. They didn't do a very good job. The rules and regulations were still there. But the Trudeau government has been seen as sort of spitting in the face of Western Canadian resource development time and time again. Whether it's fair or not, they've been viewed very, very critically in the rest of the country. So ultimately, this whole process is going to be worked out in Dwight's court. It's going to be worked out in the legal niceties, and going back to constitutions and balance of power and things of that sort. But I guess I'd put it to you this way, Aaron. I think essentially what happens is there's a 7-game series here that's being waged over the battle over natural resource development. The feds are up 3-0. Alberta has just won 1 game. And so I think it doesn't exactly tip the balance. It doesn't make it equal. It's got to go to the Supreme Court. Supreme Court's not been well disposed, I don't think, to taking the provincial rights approach on not just on this issue, but other issues. So the series is not over, and I'm not even all that optimistic.
Boy, like you say, Ken, not an optimistic view. I don't know if it's 3-1 in this series. Maybe we'll go for a 3-3 tie, and the Supreme Court is the rubber match. How about we go with that? Heather, I wanted to sort of get your view. I know you've done a lot of work with, for example, one of the interveners on the case, the Indian Resource Council. So what was their reaction to this decision, and sort of in the Indigenous community generally?
Well, we've been talking a lot about, there's federal overreach. That was the term that the Court of Appeal used, and federal veto over these projects. And that, and there's the constitutional division of power between the provinces and the feds. But there's also demonstrated overreach into Indigenous affairs too, and Indigenous rights. And this is, for people who watch closely, the third decision in about 1.5 years where the courts have said Indigenous economic rights are also rights, and that the federal government also has to respect Indigenous economic rights. And I think the philosophy that the Liberals have taken, that the regulatory process has taken, and since the duty consult, the general philosophy has been that the government needs to protect Indigenous nations from industry, and that Aboriginal rights and treaty rights and impacts on the land was the tool or the mechanism to do that. And here, for the third time, like I say, in 1.5 years, Urban Skin and Alta Link are the other court cases. The court is saying they also must consider the economic interests of Indigenous peoples. And if a resource project has economic, benefits to the Indigenous nation, that is also part of their Aboriginal and treaty rights. So this is very interesting to me, that we're starting to see some decisions that are really lending weight to the right of Indigenous peoples to say yes to development, and not just to say no.
Yes, that's an excellent point, and perhaps part of the decision that was overlooked a bit in the sort of rush to focus on the division of powers. But I do want to sort of go back to that first, Dwight. Can you sort of maybe unpack for us a little bit what the reasoning was? Was this a sort of straightforward assessment by the court saying that, look, this is a federal law that is it is trying to essentially operate a Trojan horse to allow the federal government to sort of grab power over areas that constitutionally it's just not supposed to have? Was it really that sort of straightforward an argument from the court?
In some ways, I mean, it's a very lengthy decision, and so whatever we say is going to oversimplify it a little bit. But in some ways, the court is putting a lot of context that sets up this conclusion that's that's almost reducible to the kind of thing that you're saying. So what they're specifically saying is that on validity grounds, the grounds of what's within the powers of the federal government versus what's within the powers of the provincial government, that this law is not within the powers of the federal government. It's ultra vires the federal government is the term sometimes used. I guess today's title is out of bounds, but it's more outside the powers of the federal government. And the key step in getting to that conclusion is that they need to do what's called characterizing the law. And so they examine what the law is really doing. And there's a technical term for that sometimes called the pith and substance of the law, but they're sorting through what's the law really doing. And this law takes up regulation of all types of resource projects, even those that are entirely intra-provincial resource projects. And so the other key piece to the reasoning here is that the court gives this background to Section 92A, the Natural Resource Jurisdiction Clause in the Constitution, which says that natural resource development, exploration, and so forth are within the jurisdiction of the provinces. That was an addition in 1982. It hasn't received all that much interpretation in the courts or in commentary. It's received some important commentary, but it hasn't been used as much in the courts as it could have been thus far. And this court goes through a bit of an extended discussion of that, how it emerged from the history, the long history of the Western provinces being denied their own natural resources, the eventual adjustment of that, and then the 1982 amendment. And the court ends up saying that that natural resources are within the jurisdiction of the provinces on this basis, and it follows from that that an intra-provincial resource project is fundamentally something to be regulated by the province. And I mean, all of this is oversimplifying it, but in doing that, they reach the conclusion that it's outside the powers of the federal government to have a federal veto over intra-provincial resource projects across the board in the way that the federal government had set up. There's a second more technical constitutional argument that the court hints that they might have been ready to engage with, but they don't need to, and they would have liked more material on it if they were going to, on a technical doctrine called interjurisdictional immunity. It's one oriented to protecting the exclusive core of powers, and they talk about that. Yes, this does apply to the exclusive core of provincial powers as well as federal ones. They don't take it up in this case. They're able to deal with the exclusive powers and avoid duplication just through the validity analysis. But there's that second argument that will be of interest to constitutionalists, maybe not to most viewers, but I just can't refrain from highlighting it because it will be of interest to those that work on division of powers.
You've got to take the opportunity to talk about it when you can, right, Dwight? But
yeah.
And just to clarify for terminology for folks, when you're talking about intra-provincial projects, you're talking about projects entirely within a single province, as opposed to inter-provincial ones that might cross boundaries, right, where there might be federal jurisdiction. But you're saying if it's entirely within one province, the Alberta Court of Appeal is saying that is provincial jurisdiction.
That's right. Yeah. And sorry, I should have clarified that these intra and inter terms sound alike and we use them all the time. But intra-provincial, we're talking about projects within a province. And that's, according to the Alberta Court of Appeal, within provincial jurisdiction.
Okay. And Ken, just sort of speaking of provincial rights, you know, for parts of the country that feel like perhaps sometimes everything's being run out of Ottawa. I know you'd mentioned the cheering at the decision. Do you think that in you know, in your neck of the woods, this is seen as a significant victory for provincial rights? Does it matter very much to places like Alberta and Saskatchewan?
Well, I think it matters a great deal, and it matters a great deal both at the legal and business level. And Shannon can talk about that even more directly than I can. But it's certainly functions at the political level, and I think it's important to put this kind of a decision in a larger political context. Not because the judges are making a political decision. Dwight's correct. This is a very technical answer to a very technical set of questions. But look what's happened to the West over the last say 7 or 8 years, since the Harper government sort of was defeated. We've got a very slow approval on pipelines. Western Canada is furious about that. Increasing regulations on resource development, like Bill C-69, the West was really angry about that. And the West, in this part, Heather can talk more about this, also includes a lot of Indigenous people seeing a lot of interference in their affairs. You have this sort of net zero objectives where where people in the West are always looking to Ottawa and saying, when are they coming at us? We know they want to shut down the oil and gas sector. They talk about just transitions of workforces. It's a bit of a joke out in Western Canada. So we're just going to close down the oil and gas sector and we're going to do all these kinds of things. So you put that in that context. Remember, too, that this is Western Canada was where a lot of the support for the Freedom Convoy came from. It certainly got picked up speed as it went across the West. So these are all part of a piece where Western Canada has been increasingly sort of frustrated with Confederation. Not a new theme, as Dwight said. This is going off since Confederation itself. It is one of the fraction lines or the fault lines in Confederation, and it's actually getting exacerbated. It has been over the last 6 or 7 years. So it's kind of worrisome in that context. And this is one of those things that say, okay, maybe Confederation does work. So right now we got a bit of a reprieve, and you think, okay, the courts are at least going to back the provinces on this one issue. It could actually resolve a fair number of the tensions. If it goes to the Supreme Court and the Supreme Court rejects this decision, you could see the tensions flare up again. And you could get, watch what happens in federal elections. Western Canada is not pleased.
Well, Ken, I thought I detected a few sort of flashes of optimism there, but you successfully put those out, I think, by the end. It's interesting, too, when you draw the distinction with the Harper government, who you said sort of they talked a big game, but they were not very successful in removing some of the obstacles. Now you have a different government, and they're sort of, a lot of people argue, putting more obstacles in the way. So it was bad enough when you couldn't get rid of the existing ones, and now there's even more to deal with. And speaking of obstacles for, Heather, you had something.
I just wanted to quickly respond to that. Like you said, if you have a chance I want to talk about, the Western alienation and the problem with Ottawa. And here's my chance is that Confederation would work so well if we treated it like Confederation. And I think for a lot of us out West, there's a sense that Ottawa is encroaching more and more and trying to centralize things. And that our interests, we're a big country, we're a diverse country, we have different economic interests, different cultural interests. And so trying to, make us all fit the mold that the federal government, and as the court says that they deem the public interest is a recipe for disaster. And we're seeing that. We're seeing the polarization, we're seeing the alienation, and we're seeing, the opposition to that. And so I think it is very important that the courts come up. I think a lot of Canada's polarization issues would be addressed if the federal government stuck to federal, division of powers and the provinces stuck to their powers. And so that's why this is a cheer for those who depend on natural resources, and it just happens that Alberta and Saskatchewan are more dependent on natural resources and exports and have to compete globally. And so it's important that there aren't constant obstacles put in their way.
Yeah, I think you make a good point just about federalism generally. I think, the people who would defend the federal government's position on this would say, well, this is just too important to leave to the provinces. Well, that seems to apply to everything. I mean, they did it for daycare. They interfere on sort of illicit drug policy. They want to do dental care. It's sort of everything is so important that Ottawa needs to do it. It's not a very good way to sort of defend a constitutional framework. But I digress. Shannon, I wanted to talk about the impact, of course, on industry, because that's really what this law is about what does it mean for our ability to get projects built? Because this is just the Alberta Court of Appeal, because it's not the final say. Do you think there is a big impact on the prospect of oil and gas development, or is this more still going to be just a sort of wait and see? Because until the Supreme Court says something, it's not really the final word.
No, I think that in the industry, there's a lot going on, right? That we have a whole global energy crisis going on now, and lots of producers around the world looking at what does that mean for them? Do they drill more? Do they not? There's a lot of discussion in the news about, the security of supply and what's going to happen in terms of investment generally. And then, of course, people at the same time are trying to look at what they're going to do about climate change and those types of investments. I think one thing that struck me in the dissenting opinion of this decision was when the judge said it's not up to the federal government to write laws in a way that accommodates industry. They have to do what they need to do. And to Heather's point, we are in a global competition for capital. And part of that is being able to predict what a regulatory process is going to involve. Part of that includes knowing how long it's going to take, because the money will move somewhere else. And the decision points to the idea that if something on the designated projects list ends up triggering a review, like an in situ oil project, there's not a clear timeline to know when that decision may come. Some of the factors that might go into decisions, there's a long list of factors. And so for businesses, trying to predict how that's going to go and when they might expect to move forward, all of these things become hard. And I think, in a response, if I could respond to that judge, I'd say, maybe it's not the duty of the federal government to accommodate business, but having a functioning regulatory environment that is predictable is good for Canadians. It's good for Indigenous aspirations in the resource sector that Heather was speaking about. So this is part of what's good for Canada as we look at how are we going to get this to work. And right now, there's lots of reasons why people have questions.
Right. And to your point, maybe it's not so much about not wanting to be regulated as it is about making sure that the regulation is reasonable and predictable and not duplicated. And so, for the judge to say that it's not for the federal government to accommodate industry, well, maybe the ones that should be making that decision are in the wrong place. Maybe it should be the province that is sort of making the decision. It should be making the decision. So it's not a question of if, it's a question of whom. Heather, I wanted to come back to you on the Indigenous issue in terms of the impact on Indigenous groups, because I don't think this is something, as we mentioned earlier, that gets enough attention. How has this decision impacted the view in the Indigenous community about their ability to partner with provinces and industry on these types of projects?
Well, here's the key line, for me that, the court used, the witty line that they had is it smacks of paternalism. So there's some arrogance in the federal government in the Impact Assessment Act and the way that they've applied it. For example, in the Ermineskin case, that they know better what is in the interest of Indigenous nations, the court used the term entity, than the Indigenous entity themselves do. And so with the Impact Assessment Act, Indians and lands held for Indians falls under federal jurisdiction. It goes even further so that they say that any change occurring to the health, social, or economic conditions of Indigenous peoples of Canada is a federal responsibility. And as they said in the opinion, that could mean anything. It's any Indigenous person anywhere, any social or economic or environmental effects. So it goes much further than environmental impacts on their traditional territories or on their reserve lands. And so in this case, and this is what the Indian Resource Council, for example, argued, and so did the Woodland Cree, that was the other intervener that was strongly against it for this reason, is that if they could deem a project an oil and gas project, in their case, or a coal project, or anything that goes against kind of the government's, greenhouse gas emissions or Paris Accord goals, that they could deem it in their own interest, enter into an agreement. And this isn't hypothetical. This is what happened with Ermineskin, for example. Enter into an agreement, an impact and benefit agreement with the industry proponent, get the approval of the province. And then the federal government can still come in and say, we reject that because it goes against Aboriginal and treaty rights. And so that's what smacks of paternalism, I think, for a lot of First Nations, that they see the First Nation will use their Aboriginal rights against them. And it's not the federal government's to give those rights. Those are inherent rights. And it's for the federal government to respect those. But the minister, under the Impact Assessment Act, has specifically argued that Aboriginal rights do not include economic rights. That, for example, you don't need to have a duty to consult on economic issues because that falls outside of what they consider Aboriginal rights to be. And so there's a lot of overreach from the federal government in the Impact Assessment Act. And as you see more Indigenous nations being the proponents of resource development projects, being partners in resource development projects, having equity, then the tables are turning where people used to use Aboriginal rights as a reason to reject resource development projects. Now it's going to be harder to reject those if the Indigenous entity wants those because of the economic interests. You're muted.
Sorry, far be it from the federal government to find more than one set of toes to step on, not just the provincial rights, but also, of course, Indigenous rights. To a 2-for-1 in this law. I had a question about the nature of the decision. In terms of the fact that there's a parallel with the carbon tax decision. So sort of Dwight and Ken, I was going to look for your insight on this. Should we read anything into the fact that now this is twice now that the Alberta Court of Appeal has ruled in favor of provincial rights in similar references with respect to the constitutionality of a federal law? And so does this maybe position the Alberta Court of Appeal as sort of a voice for provincial rights? Is there a trend developing here, and is that a good thing? Is it a good thing if people in certain provinces see their courts of appeal as sort of standing up for them, and the Supreme Court as being the sort of voice of Ottawa?
I would read in two things to this. So first, I would read in that the Alberta government has made smart decisions about two decisions to refer to their Court of Appeal, where there were statutes that were questionable and that needed constitutional challenges. The second thing, though, that I would read in, I wouldn't describe it so much in terms of the Alberta Court of Appeal standing for provincial rights so much as the Alberta Court of Appeal standing for a very principled approach to federalism in line with a lot of prior jurisprudence. And there are some challenging questions around that in sort of the current period, where maybe other courts are approaching federalism in Canada a little bit differently today, and the Alberta Court of Appeal may have a different approach than some other courts. That's an interesting phenomenon, but I wouldn't want to describe it in terms of courts standing up for the people of their provinces so much as courts standing up for legal principle, and the Alberta Court of Appeal has done that in these two decisions as best it sees it.
Okay, Ken.
Yeah, that's really interesting. And Dwight's got a brilliant answer, of course, to that. And that's how we want the system to operate. We want the courts to work on legal principles, work on the actual text of the laws, and actually follow the Constitution as they should. There's another side to these processes, nothing to do with the lawyers. It has to do with how the public perceives these things. And I think the other side of this is the public is perceiving this as sort of the court standing up for Alberta. They certainly saw this with Saskatchewan courts on the carbon taxi kinds of issues. The carbon tax issue is a good parallel, only in as much as the provinces went in one direction and the federal government won. In this case, the courts stood up on behalf of the federal government. I worry this a little bit, and Heather was talking about this in talks or context about Western alienation. These things are not always logical, they're not always precise, they're not even legal. They're just sort of reporting how people are feeling about the country. And one of the things that happens, the carbon tax, now we're seeing it in the context of rising oil prices because of global affairs and market pressures and things of that sort. Now the carbon tax seems like an absurdity. A lot of people are sort of, just get rid of the carbon tax. We don't need it. If the whole idea of the carbon tax is to raise the price of gas so people will stop driving, hey, the market is taking care of that, right? So at least maybe even for 6 months, cancel their own carbon tax, give people a break at the local level. Why not going to cancel it? Because it's ideological. So I think the issues here is we're seeing this interesting boundary and transition between what goes on in the courts, which follows exactly the principles Dwight's talking about, and how it's perceived in the public, which is in a context of 150 years of Western alienation and growing unrest in many parts of Western Canada about how Confederation works and doesn't work. So at this point, after this decision, it looks like it's working okay. If the Supreme Court turns its back on it, whether it's legally right or whatever, and it'll look as though Canada's not working for the best interests of Western Canada again. And as a passionate Western Canadian, I worry about this a lot. There are some deep roots of anger showing up in fragmented parties, the radical right in the province of Alberta, in the UCP, and the overthrow of Jason Kenney. We see this in the Buffalo Party and these other kind of groups that are forming across Western Canada. People are just don't believe that Canada is working for them. Right now, that's a minority movement. It's the 5-10% sort of category, maybe 15%. Doesn't take much to tip this into sort of closer to majority territory, and I worry about that.
Yeah, that's a fair point, Ken. I was gonna sort of turn now. We got quite a few interesting audience questions, so I wanted to sort of toss a few out there. One of there was some questions about investment again, Shannon. So I kind of want to know. We talked about whether the Alberta Court of Appeal decision changes anything, but I guess let's put the hypothetical to you: if the Supreme Court upholds this decision, and so that the IAA is history. I assume that's going to be a good thing for the sector. Then they're going to see that as a sort of green light that this law, which was frankly hampering investment in the development of new project, that's out of the way. That would be a good thing if the Supreme Court sort of has the final say and upholds the Court of Appeal.
Well, if the Supreme Court upholds the decision and finds that the IAA and the regulation are unconstitutional, it doesn't mean there'll be no more environmental regulation in Canada. So I think what will happen next is industry will be very interested to see what's going to replace this policy and how is the government going to make the Assessment Act constitutional, but also meet the needs of environmental review. And so I think there'll just still be some question marks about Canada's investment environment before people can know and predict how do we move a project forward. Now, there are things that get to potentially done to mitigate that, but I think that'd be the immediate effect. It's like, okay, now we have a better understanding of how to look at federal and provincial division of powers, but what does this mean now?
Yeah, so there's actually another step beyond the court decision, because as you say, if they still want to legislate in this area, they may find ways to do it. And of course, industry is going to want to know what that is before they sort of make any big decisions. I guess there's some legal roulette here, Dwight. Steven's asking, what do you think the odds are that the Supreme Court overturns this decision in the same way that we saw with the carbon tax?
Oh, it's always risky to make those kinds of predictions. I'll just say that there are dimensions to the Alberta Court of Appeal decision that might even be speaking back a bit to the Supreme Court of Canada's decision in the carbon tax case. So it'll be interesting to see how the Supreme Court of Canada reacts. There's going to be a slightly different group of judges there than heard the carbon tax case, just because of transitions in the court. But not a massively different group of judges. And so maybe things work out about the same, but it is on a different set of facts, a different set of considerations. But to the extent that there's partly a dispute over some issues of how to go about living with federalism, the question is whether the Supreme Court hears this message that other courts are actually speaking back a bit to what they said before. So I mean, it's always difficult to predict those kinds of things. The standard betting, I guess, would be that the Supreme Court of Canada is going to overturn the Alberta Court of Appeal decision, but I don't think we should ever make those decisions or those predictions in advance.
Yeah, I concur. I get nervous when people make guarantees about what the outcome on any court's going to be. You got 7 or 9 individuals, and sometimes it's a mini democracy in a sense of experts, right? And so you can have 4 votes for one side and 3 for the other, or 5-4. I'm getting a lot of questions about the Supreme Court's sort of odds and likelihood of it being overturned. I did have a question also, though, about obviously in Alberta, and I don't know who wants to take this one. Just sort of observing that because Jason Kenney's leaving, there's obviously going to be some political uncertainty in Alberta, and how that compares to what the impact of that political instability as compared to this decision. Is it similar? Is the sort of political uncertainty in terms of who will be leading the province and what will happen in the election, is that of a similar caliber to sort of waiting on this particular piece of legislation, or is it not as a big deal?
I'll jump in quickly. I don't think it's the political instability in Alberta is as big an issue, and for the simple reason that all political parties in Alberta are kind of opposed to federal intervention in the natural resource economy. Rachel Notley, when she was the premier, fought very hard again on pipelines in particular, but on natural resource things generally. So there's a kind of a bit of an Alberta consensus, as there is in Saskatchewan, sort of on this issue. But I hope folks are paying really close attention to what Heather's saying about on the Indigenous side, because we have seen a complete reversal of where we were 25 years ago, where Indigenous people were seen as sort of a drag on the industry and slowing things down. There's an irony in all of this, and I think I'm not sure how this plays out legally, Dwight and Shannon, in this particular case. But the language in the document about the interference with Indigenous affairs is really important. Because it's sort of hitting Ottawa at its most vulnerable point. Ottawa is unbelievably paternalistic toward the government, toward Indigenous people in this country. It can't stop itself. It really does believe it knows best. And here you got a court coming back and saying, hey, folks, stop this. Publicly, chiding them for actually interfering on the decisions of Indigenous people, and said their mentions in more than one case. So I think the interesting thing here is that Indigenous engagement is actually strengthening the hand of the natural resource economy in some particular ways. And pick up what Shannon said before as well. The industry does not want to be unregulated. The industry is not talking about getting rid of all regulations. They're perfectly comfortable, and they've adapted remarkably well to an incredible series of intrusions in their decision-making processes over the last 50 years. Not always happily, I would say, but they have responded and adapted to the sort of the new rules and new regulations, and they've accommodated the rise of empowered Indigenous peoples in some very deliberate and very specific sort of ways. So I think we're actually seeing a realignment that may have some legal implications here as you go down the line, because we're going to see First Nations people perhaps intervening on behalf of these kinds of cases and demanding that the federal government back off and let them make decisions. I have a high level of comfort with First Nations people making ecological, environmental decisions relating to their traditional territories, much more so than I do some very highly technical process with competing scientists who are waging war against each other. Indigenous folks are going to be on that land for hundreds of more years. They want it looked after.
Heather.
Yeah, I might add to that. Ken said a lot of smart things there. I agree with all of them, and there's a lot to unpack there. And so I might go off on a few tangents, but maybe I'll start, because Shannon can't say it herself, but part of the reason why the Indian Resource Council is an intervener here, and we are seeing alignment between a lot of First Nations and other Indigenous groups and industry, because there's mutual benefit. And that is very different from where we were 25 or 30 or 50 years, certainly. And now the courts are also seeing it and also recognizing it. So that is a very monumental shift. And so the old thinking, and I think it's still a current thinking in some parts of Canada, that industry is, First Nations are victims of industry. That has to evolve. The other thing I wanted to say was about risk, because it's been brought up a few times here. And one thing is, I know, it's sometimes the argument that the Impact Assessment Act doesn't apply to that many cases. There haven't been that many cases where it has been applied. And I know that people in the oil and gas industry would say there's a lot of projects that just don't even make it to that stage because of the uncertainty, because of the cost, because of the burden on industry. So that's not a good measure to say how well is industry doing under the IAA, because so many are just think it would be futile, to, for example, try to do another pipeline under this act. But I want to relate that to the Indigenous side. The federal government has made it very risky and more unattractive to invest in Indigenous territories with Indigenous partners on things like Coastal GasLink and Wet'suwet'en, where it seemed like it was a slam dunk, where the elected bands had signed agreements. And then there was protests and there was controversy, and the federal government really seemed to come out on the side of the hereditary chiefs and against all the process that had been done. And that makes any investor feel very leery about any project on Indigenous territory, on Indigenous lands, with Indigenous partners in the future. And there's even risk premium associated with doing business. And when you're an Indigenous nation and you're trying to do economic development, and you're trying to address poverty, and your best source of capital is the land, is the territory, those resources that you've been managing, like Ken says, have been managing well for thousands of years, no better than anyone else, what the land can absorb and not. For the government to make it impossible for them to act as nations and as businesses and be able to compete for that investment, I think one day we'll see it as unforgivable. And these kinds of decisions that we've seen with Ermiskin and AltaLink and this IA appeal, I think it will set the stage. I'd be curious on Dwight's opinion on this in the future for First Nations to come back and sue the federal government for having blocked, some of their economic development opportunities consistently, structurally, for 2 decades.
Yeah, Dwight, I kind of want to get your thoughts on that because, again, we often look at sort of federal intrusion as, the impact on the provinces and then the impact on industry. But now, obviously, we have a very sort of clear third group being impacted here negatively as Indigenous groups. So, is the federal government perhaps exposing themselves to headaches down the road by passing laws that are clearly having negative economic effects for Indigenous people?
So that kind of legal claim needs to build up pretty gradually through the case law in some ways. But I think I agree with Heather that read this decision alongside AltaLink and alongside the Ermiskin decision. You're starting to see some of that law building up that's in some manner recognizing economic rights held by Indigenous peoples that the courts will recognize in some manner. There's a lot of challenging steps to turn that into a legal cause of action. But if enough law built up, as Heather has said, down the road, looking a number of years down the road, as that law continues to build up, there may be possibilities along those lines. Some have asked the question whether there would have been a duty to consult challenge available in the context of Indigenous nations that were not consulted about decisions to cancel projects, for example. And in some ways I have sort of the same answer on that it takes a bit for that law to build up because you need a recognition that the economic right has a constitutional protection. Well, we're starting to get there when you have a decision like the AltaLink decision and a decision like the Ermiskin decision and a decision like this that start to recognize some type of legal status to the economic rights of Indigenous peoples. And so these things could develop over time.
Okay. Shannon, I wanted to sort of go to you with a question about sort of whether things have changed for the federal government. I mean, we know that this law came about, and this law has been law for a little while because the federal government takes a very sort of aggressive view on emissions. A lot of people have argued that because of things like the war in Ukraine now, a lot of countries have had to sort of reassess their energy mix, sort of take perhaps a more realistic view of things. What's the sense in the industry as to whether the federal government has sort of followed this trend, like countries we've seen like Germany that have sort of reassessed where they're getting their energy from, what they're willing to accept in terms of facing the real politic of what's going on in the world? Is the industry sort of optimistic that the Trudeau government is taking a more realistic view of the situation?
I think that the minister has made a number of comments, and it's currently at a G7 meeting in Germany with Minister Guilbeault, and the message has been consistent that the government wants to do something about energy security globally, but is also very committed to achieving its climate ambitions, and that even as it helps its European and other allies, that the way that help is delivered, which they made reference to the 300,000 barrels per day extra capacity that Canada might be able to deliver. The way that is delivered should not increase emissions in Canada, and if there are net increases, it needs to fit within the climate plan. So I think that remains the North Star of the way the government approaches the full picture of what it's doing. And obviously, industry is paying close attention to those messages as it looks at its own project plans and kind of the policy landscape in which we're operating.
Yeah, fair enough. And Ken and Heather, I don't know if you have thoughts on that either, about whether you think this has been a sort of reality check for the federal government in terms of how they balance their climate change goals and industry.
No.
You go first, Ken.
I mean, mine's a sharp no. I mean, I think they've made their decisions. They're sticking to their guns, and they're going to go down the ship with that one. The good, bad, or indifferent. I'm not making a judgment on their plan. They've made a commitment to sort of the net zero strategies and whatever, and they haven't been very flexible on that at all, even in the face of situations like what's going on with the Ukraine and what's going on in Europe, sort of overall. Also not in the face of sort of the realities of the situation. Some of the research has shown that the carbon taxes disproportionately hits people in rural areas. The surging price of gasoline, if you're living in a small town in Saskatchewan, you can't jump on the subway and go to work. You got to drive your vehicle to go to work, right? And so, in urban areas, people are saying, well, we got all these alternatives. We're spending billions of dollars on transit systems in urban areas to allow urban people to get out of their vehicles if they choose to do so.
There's no subway. There's no subway in Swift Current, right, Ken?
There's no subway in Swift Current, and it's a really serious sort of problem. And I think we have a rural-urban dimension to all of this. And the government of Canada, no criticism of them for doing this, is very much an urban-based party, reflecting urban-based values. And I think we've got a more fundamental issue there around that. I was just in the Maritimes and talking to the folks there about how the fishermen are dealing with the rise in oil prices, and it's a staggering impact on their costs, right? I haven't seen the federal government jump up and say, oh my gracious, we can't have this affecting these people so profoundly. So no, the government's not likely to budge very much unless Heather's seeing something I'm not seeing.
No, not at all. So to bring this back into the context of the IAA, it's not a conspiracy theory, to say that this was brought in, this new Impact Assessment Act, so the federal government had the power to curb oil sands and oil and gas projects. That's obviously part of the intent of the IAA. And that's why it was, called colloquially the No More Pipelines Act. Because under this, if anything added more greenhouse gas emissions, which everything adds more greenhouse gas emissions, any industrial activity does, then the minister has the power to veto it. That's basically how the IAA works. And so I have heard nothing. And so now we have a supply crisis. Now we have an energy crisis. And at our MLI event last week, all anyone asked me from Hungary, from Japan, from New Zealand, from United States, any of the embassies on the break was, can Canada produce more energy? Why isn't Canada producing more energy? All of our allies want Canada to produce more oil and gas, but we don't have the framework. There's no confidence, I would say, for investors to go out of their way and produce significantly more. Just in London today, in the United Kingdom, I don't know if people saw the news, but they announced a windfall profit tax. People have been talking about that as kind of a popular solution. But at the same time, incentivizing through tax credits any new production. So really, after how many years, 10 years, they just hosted COP26 there a few months ago, saying that we can have no more oil and gas projects. Now they introduced today a whole new slate of projects to try to incentivize that production. And so I always say this, the energy crisis will come the last and least to Canada because we are so blessed with so much energy, so much cheap energy, every kind. But it is hurting people today, and Canada could help solve some of that global problem. But I have not heard anything publicly from the federal government that suggests that how they approach it, before Ukraine is how they're going to approach it post-Ukraine.
Yeah, fair enough. We've got a legal question here, Dwight. Joseph's asking whether there were any other areas that the Alberta Court of Appeal had criticized the IAA besides the jurisdictional grounds, the federal provincial issue and the Indigenous issue. Was there anything else of particular note in that decision?
Well, I mean, they're not setting out to criticize the IAA specifically. They're not engaged with the policy in the IAA. They're making legal determinations on the IAA, and they do that on the arguments that are there. There are lines in the judgment that some have taken to amount to some other kind of comment. So there's a line that refers to the IAA as imposing an economic chokehold on the provinces, for example. And people have said, well, is that engaging in a political comment of some kind? And I would tend to say no, that it's not. Obviously, every decision has political implications, but the fact that they use a colorful style in describing a legally coercive effect of a particular piece of legislation in the context of division of powers doesn't make it a political comment. They're trying to describe in a vibrant way the dimensions of the act, the IAA Act, that shift a balance of power between the provinces and the federal government. So I would say that they are focused upon those legal considerations. It's a very extensive legal analysis, and that's the main thing from a legal perspective to take from the judgment. Of course, Ken can come back and say that the public can perceive some other things in it, and that's fair enough. But from a legal standpoint, they are engaged with jurisdictional issues, and then at a second level with those Indigenous issues and the interjurisdictional immunities issues they referenced earlier. So.
Well, I do want to come to Ken on that in a second, but I can say, having read my more than my share of judicial decisions, having more colorful language is a good thing, because some of the decisions can be quite dry. So I certainly appreciate the court trying to turn a phrase in a way that's going to resonate with the reader, sort of make it more easy for especially lay people to understand what the court is getting at. With respect to the sort of political fallout from these court decisions, I know, and we've been talking about in sort of the pre-chat a little bit, Ken, about the politicization of courts in Canada. You know, south of the border, there's obviously a very sort of open partisan divide on courts. Everything from the confirmation process to judges, you know, past history and rulings are sort of parsed very finely, and people are sort of categorized as very liberal or very conservative. We haven't had so much of that in Canada. Some would argue that there has been politics, it just hasn't been as overt. So I wanted to get your thoughts on, you know, we talked a little bit about it, but is this a problem that's getting worse with the courts? And you know, is it something that's avoidable, or is this just inevitably the direction things are heading?
Well, I actually think we're blessed with the court system that we have, and we've actually selected judges very well and very effectively over time. They are generally nonpartisan, even if some of them have political backgrounds and whatever. They've actually held up their part of the bargain really, really nicely and very, very consistently. So I think, and particularly with the Supreme Court, you know, there's people who got really angry over the last 20 or 30 years of judicial activism. But in fact, the Supreme Court was reflecting a changing Canada, and the, you know, changing needs of a very different and diverse populations. And so, you know, we didn't like the fact that they were doing stuff that government refused to do. The reality was governments were refusing to do it. Governments weren't actually making decisions, and we were deflecting a whole bunch of important issues, you know, back onto the Supreme Court. I'm one of those very few rare people in Canada who's really quite sad we have the Charter of Rights and Freedoms brought in. I think it actually changed profoundly the dynamics of parliamentary democracy in this country and made it much, much easier for governments to sort of avoid major issues and deflect them onto the courts, which I don't think is necessarily in the best interest of Canada. But I think that I hope we don't politicize it. One of the problems, Dwight mentioned this very nicely, was he said, this is a really complicated, long document. The public is only going to read the headlines, and the public's only going to react to sort of 5 or 6 phrases and a couple of words and here and there. That what happens is it blows up into this broader thing. My worry is that the politicians, right now it's the Liberal government, later it'll be a different kind of government, will actually start paying too much attention to that and start looking at, hey, we're not going to appoint this lawyer to the or this judge of the Supreme Court because they're not in line with our views on environment, or not in line with our views on individual freedoms, or whatever it happens to be. We let the process select a really good candidates. And when I look at the people who are shortlisted for the Supreme Court each time and the names get circulating out there, these are brilliant, brilliant, brilliant people. And I think we actually do really, really well in finding people into our court system. I hope our politicians leave it alone as much as they possibly can.
Maybe Dwight, I'll come back to you briefly just to sort of put that question a little bit differently. You know, in terms of judges having political views, and those insofar as those views can manifest themselves in decisions, and we can just use the IAA as an example. You know, you're someone who watches, you know, you read a lot of legal decisions, probably more than the average person. Is it the case that when you see a decision come down, you're usually not surprised by where certain justices fall when there is a debate and a decision? I'm not saying that you'd predict it with 100% accuracy, but is it fair to say that over time, if you read decisions by a court, you can come to sort of predict where when a new issue arises, sort of where the justices might fall? And so following on that, were you surprised with the decision in Alberta?
So you might have certain kinds of guesses. They'd be based not on what those judges think about particular policy issues, but based on those judges' approaches to legal reasoning, their approaches to interpretation of the Constitution, their interpretation of statutes. But we don't have massive divides in Canada like in the US. And even the US, it gets exaggerated just how much the judges are divided, because they decide a lot of decisions all together, or they split in different ways than is expected. So I'd say sometimes you have guesses where particular judges might end up, given the nature of the issues and what they legally need to do to get to an answer. But to turn that into very much of a prediction is challenging, because there's an argument going on there. There's a discussion going on amongst the judges in the back rooms, and then someone's trying to write a judgment and persuade their colleagues, and so on. There's a legal process that's involved that's not pure politics. That's very different than politics. If it were just politics, we'd have no reason to run our country by a council of 9 people, as opposed to a normal parliament. But there can be elements where there are approaches to interpretation and so on that can be guessed at a bit.
Okay. Well, look, we're down to the last couple of minutes here, so I just kind of wanted to go around the horn one more time and sort of see if anyone has any final remarks, any other observations, or anything we didn't get to touch on about the decision and about sort of what you hope to see going forward. So maybe we'll start with you, Heather.
I mean, a lot's been said. I think as Dwight mentioned, and as people would hope, this is starting to set the case to recognize economic rights as Indigenous rights. And I think this is very positive. And I think it's also a bit transformative in the current Canadian landscape. And so I feel happy for people like the Indian Resource Council and the Woodland Cree and other interveners. It's not easy for a First Nation to go to court against the government and to pay for those lawyers and to do that intervention and to dedicate that time. And the Indian Resource Council, for example, was very active against C-69 also before it was an act, because they did see it threatening their interests. And so I think this is a victory. You know, they've been arguing for their own rights, trying to fight for their own rights for going on, maybe 4 or 5 years now. And so I am pleased that somebody is seeing, the kind of the fundamental unfairness of the federal government thinking it knows better than Indigenous nations themselves of what is in their own interests.
Absolutely. Shannon, your thoughts?
Well, I guess, my hope is that Canada can somehow find a way, and it's not just a challenge that Canada faces, but the United States as well, to move major projects and infrastructure back into a kind of a technical space, that we can have policy in the country where we say, okay, we want this kind of development, and provinces will determine how they want to develop their resources, and that'll be really clear. And then there can be rules that are predictable, that lead to decisions based on the technical merits of a project, because the policy question was settled, and projects could proceed or not proceed, and stakeholders, including proponents, Indigenous partners, and others, can have these projects move forward and see those benefits move forward without there being political uncertainty in the context of projects. And so I think that'll be a positive development at the end of the road on this.
That sounds reasonable to me. Dwight, your thoughts?
Well, just speaking to the value of getting to clear rules, I mean, putting that into another context, I hope that this decision, amid the push and pull between different courts, can be part of a process of getting us back to clear rules on the division of powers, on federalism, that are then applied in ongoing disciplined ways, so that everyone knows what the powers are of the federal and provincial governments, and can act based on that and negotiate based on that. And we'll all be a lot better off if those rules can be clear and respect Confederation and respect all the provinces of Canada and the regions of Canada and the diversity of Canada in some complex ways. That's a hope out of this, but we'll see what comes.
Okay, and last but not least, Ken, I'm counting on you for a dose of positivity to wrap things up here.
Well, I'm not sure you're going to get it. I know these are wonderful comments from Heather and Shannon and Dwight, and I agree with what they're saying. But the main message here is that federalism is a really messy political process. Always has been, always will be, is in every country that has sort of a federal system. But I think it's important when we look at issues like this, wondering whether federalism is up to the task. And I really like what Dwight said, because he was in his very technical and professional way, sort of cautiously pessimistic and hopeful at the same time. We have to accommodate Indigenous rights within federalism much better than we do now. Think for a second of what it means, where Indigenous people are having to fight for every single one of their rights through the courts, taking decades and decades and hundreds of millions of dollars to do so. That is no foundation for real Indigenous engagement with the federal system, sort of in this country. And I think when you look at the issues around oil and gas, these are complicated global economic business kind of decisions, and federalism moves very slowly. And we get court cases and another court case, and we go levels of appeal. Meanwhile, the country, the world needs our energy yesterday. The world needs our engagement much more quickly. And so what this process sort of slows. Yes, this is a good Canadian way of making decisions. We don't punch ourselves in the nose. We sort of walk it through the legal process and go court case after court case after court case. It really does raise some important questions as to the degree to which Canadian federalism is up to the challenge of the 21st century. I hope it is. I'm like Dwight. I think we can move it along, but I think the world's moving way faster than we are, and we pay a price for being slow.
Well, there's enough optimism in there. I'll take what I can get, Ken. I want to thank all of you, of course, Ken, Dwight, Jen, and Heather, for joining us today. I think it was a great conversation. I want to thank you, the viewers, for joining us, and we will see all of you on the next MLI webinar.